Right, Counsel, we should probably talk about this Blakely issue, whether it's going to be a unitary proceeding or a bifurcated proceeding. I know we're getting ahead of ourselves again because the Blakely would not come up unless there were a guilty verdict, but I think we should discuss this now because it might impact what evidence goes in as we go forward.
Yes, it's our position.
Oh, could you put your microphone, maybe switch places with, no, why don't you go to the podium, Mr. Gray?
Your Honor, it's our position that we did not agree to try the Blakely issue along with the jury trial. Neither did our client. If Mr. Prosecution thinks that we did, we didn't, and I don't think there's any record of us ever doing that. In order to do that, we would have to first get permission of our client. What I understood was that if we would lose the jury trial, after the jury trial, we would have a bifurcated trial with the court and let the court decide the Blakely issues. I would never agree to combine both of them. That was my understanding, and I believe it was Mr. Ames and our client. Thank you.
Your Honor, we absolutely did discuss this in chambers with counsel. We did talk about leaving the determination of the Blakely issues to the court rather than the jury. Counsel indicated that their client would agree to that. Not a huge, real surprise to anybody that does this. And then we talked about still having a unitary trial, not a bifurcated trial. And it was agreed to by everybody in the room. Now, Ms. Potter, of course, was not in the room at that time, but her attorneys represented at that time that they would not be requesting a bifurcated trial, that we were going to have a unitary trial. And I'm a little bit concerned that counsel is now saying on the record, absolutely, we did not agree to that, because we did agree to it. It was discussed and agreed to. Now, having said all of that, again, as I said this morning, this evidence disputed today is going to come in for two purposes, the Blakely purpose as well as the fact that it's relevant to Ms. Potter's job then as a police officer, and that goes to her awareness. But additionally, Your Honor, we had a real brief discussion, is my recollection, about the recognition that the Blakely-only evidence would be very minimal, that most of the evidence for the Blakely factors would be relevant to the guilt factor, or the guilt issues anyway. And so practically there would be no need, or very little need, for a bifurcated trial. And so we do need to make a record that Ms. Potter is waiving her jury rights to the Blakely factors if they are going to stay with that position. But I firmly recall saying to the court that we would have then a unitary and not a bifurcated trial, and that was agreed to. That's the way we've proceeded with the proof in this case. And really, I think, as we talked the other day, just a little bit about the injuries to the other people down the street, there's been very little Blakely-only information anyway, if really even at all. So.
All right. I think everybody has kind of a different recollection. I'll tell you mine. I remember the issue coming up. I remember the defense saying that they wanted me to decide the Blakely issues. I don't recall that we went into any detailed discussion whether it would be a unitary or a bifurcated proceeding. I specifically do recall that a unitary trial on both was not agreed to. I don't think we discussed it at all. And I think counsel has different memory of it, but my recollection is that we didn't discuss unitary versus bifurcated.
As a prosecutor, we are very sensitive about likely issues. I mean, we know this is something that has to be handled. It's in the rules, unitary or bifurcated. So with all due respect, I do specifically remember bringing up whether it be unitary or bifurcated, and we talked about it being unitary because there would be so little evidence, really, if any. Now, if you will recall last week, after some testimony about the crash afterwards, this came up, and we discussed it then about there being a unitary trial, and this claim that counsel's trying to set up now that there's some error here wasn't brought up then. It was discussed that we were having a unitary trial on it, and that's how it was to go forward. Now, I want to add to the court, I think, that really, I think almost all of the evidence has been admissible on both issues anyway. So there is no prejudice from not having a bifurcated trial so far.
Okay, I don't think there has been any prejudice so far because the second crash relates to reasonable use of force with the taser in a allegedly moving vehicle. So I don't think there's been any prejudice, but what I think we need, I don't think it matters what our respective recollections are anymore, because what is critical is Officer Potter was not in chambers with us. There was never a record made of her agreement to have a unitary trial. The defense is now saying Officer Potter does not want that, so we're going to go with that. We're not going to have a unitary trial on Blakely and the main issues. Okay? So,
Your Honor, one of the reasons that Ms. Potter never spoke to it is because she was never required to come to court. We never had the ability to make a record with her here until the first day of trial. Because we did want to make that record. She wasn't here. So, but my understanding of the court's ruling is I'm going to try my case the same. If counsel feels that there's no doubt they will object if they feel something is Blakely evidence, we'll have to just dispute it at that point, I guess. But my understanding is you're not going backwards and striking any testimony or finding that there has been any prejudicial testimony presented so far.
I don't see any. Why don't we do this right now, just so we have a clear record? Counsel, could you deal with the Blakely issue and your client's wishes on that issue for the record?
Yes, I know.
And Mr. Gray, could you put that microphone near your mouth because the court reporter has been having difficulty?
Yes.
Okay, and put, Mr. Ng, could you put the microphone closer to your client? And you've got a microphone too. Mr. Ng, there's another microphone sitting right there. Okay. All right.
Your Honor, we do not intend to have one trial. If our client is convicted, we would want a bifurcated trial and try the Blakely issues after the factual issues in the trial. And we've never, ever discussed with our client about waiving that. I don't believe that anything was discussed in the chambers about this issue. We said we would try it to the court after the case is tried, which I assume would be a bifurcated trial. In any event, our client wasn't there, ever, and she will not waive any right not to have a bifurcated trial.
Okay. And just to be clear, should there be guilty verdicts in this case, that issue will be submitted to me. And therefore, there won't be any evidence pertaining to Blakely during the main trial here. Okay.
I'm sorry.
Yes.
Ms. Potter needs to do a jury trial waiver of her Blakely issues. A formal waiver needs to be done on the record, and now we have learned the hard way why, but that still needs to be done. She needs to waive the jury trial on Blakely issues and decide on a bifurcated process.
Okay. Ms. Potter. Let me find that. There are two Blakely issues that the state has submitted, and the two Blakely issues are that defendant's conduct caused a greater than normal danger to the safety of other people as she fired into a motor vehicle in which a passenger was present and two other officers were in close proximity while the vehicle was operational on a busy public street. After defendant fired, the vehicle traveled down the street and struck an unoccupied vehicle heading in the opposite direction. That's the first alleged Blakely factor. The second one is that defendant abused her position of authority as she was a licensed police officer in full uniform who had seized Mr. Wright. And I'm sure that your attorneys have explained to you what Blakely is all about, but those issues would not be an issue at all if you were found not guilty of either charge. If you were found guilty of one or two of the charges, your attorneys have indicated that they want me to decide whether these aggravating factors exist. The aggravating factors generally would allow me to impose a more severe sentence. Now, you have the right to have a jury decide these the existence of these aggravating factors. You have the right to call witnesses. You have the right to cross-examine any witnesses that the state would call. And I suppose you'd have the right to testify, too, if you wanted to, on those issues. You'd be represented by counsel. And the jury would have to find beyond a reasonable doubt that these factors existed. And the burden would be on the state. Is it your wish to give up your right to a jury trial on whether or not the two Blakely factors exist in the event of a guilty verdict?
Yes, Your Honor.
Okay. Counsel, do you have additional questions on the waiver?
No.
Okay. Does the state have additional questions on the waiver?
Your Honor, I would just ask the court, or I could ask the defendant if you want, but to acknowledge that she has discussed this with her attorneys. She's had a sufficient amount of time to discuss it, and she doesn't need any more time today before making this waiver on the record.
Okay. You've had time to discuss this, right, with your lawyers?
Yes.
Do you need more time to think about it? Okay. All right. Okay, counsel, let's take a 15-minute break. Okay.